Let's get straight into that promised interview with the acting Public Protector, Advocate Kholeka Gcaleka. She says she won't bow to political pressure to speed up the Phala Phala farm investigation. Some political parties complaining that the investigation is taking too long. Now, Gcaleka has taken over the investigation after Public Protector Busisiwe Mkhwebane was suspended. Advocate Gcaleka in studio now to speak about this and other reports stemming from her office. Advocate, thank you very much for making the time. Finally, this chat happens, and it's good to have you in studio. Let's start with the latest reports around the Phala Phala farm matter. The Sunday Times reporting at the weekend that your office has discretionary powers to not entertain this Phala Phala farm matter, and it's all got to do with what they are saying is a 2-year lapse, and your office has that discretionary power to decide whether or not you are going to pursue this case. Are you still determined to see it through, this Phala Phala farm investigation?
Good morning, Chloe, and good morning to your viewers. The Office of the Public Protector is investigating the Phala Phala matter. As I've previously reported, the matter is quite in an advanced and progressive stage. I will really not entertain the reports in the Sunday newspaper, but however, it's critical that I speak to the Section 6(9) in terms of the Public Protector Act, which many do raise in investigation where they're of the view that the 2 years lapse has already taken place. This does grant the Public Protector with the discretion whether to take up the matter under certain requirements. We have to prove that there are special circumstances which exist. However, in the Phala Phala matter, the Section 6(9) of the Public Protector Act is not applicable. Even though the matter happened over 2 years ago, however, how it became known into public, it was recently, and immediately after it became known, the investigation was then embarked upon, having received a complaint in this particular matter. So as far as it relates to us, the incident still falls within our mandate. Whether we agree or not whether Section 6(9) applies, we have covered all avenues in respect of the investigation. And
so you do believe that the reason you're going to press ahead with the investigation is as a result of what? Special circumstances that exist for you to see through this investigation?
Firstly, for us is that the matter is continuing, because what has been reported to us is a conduct in terms of EMEA, a conduct which is not worthy of a member of the executive. Now, in respect of our part, if indeed we do find that there has been such a breach, it has been continuing. It didn't stop at that instance when the incident took place, which is most critical considerations to make whether you believe whether a matter falls within the Section 6(9) of the Public Protector Act or not.
Okay, so it's got to do with that members of the Executive Ethics Act.
Yes, indeed.
It's in accordance with that you are persistent on seeing this investigation through.
Indeed.
Okay, all right, that makes sense. All right, then let's try and understand your approach to this matter. If President Ramaphosa raises as a defense the timing of this complaint being laid at your office, are you going to pay any credence to that? The reason I ask that question is as a result of the identity of the person who laid the complaint, including the background of that individual. Because if the president says the timing here has to do with the December conference of the ANC? Will that matter at all in terms of your investigations?
Not at all, Oli, not at all. Ours is to look into the merits of the matter, look into the evidence that we would come across, and apply the law into that and see whether indeed there is a breach or not. So issues of timing really do not influence our investigation. Ours is to do our investigation impartially and independently of any other circumstance.
Are you satisfied that President Ramaphosa has given you adequate information about where these monies would have come from and the subsequent burglary which he says took place at his farm?
According to investigators, the responses provided to them allow them to continue with the investigation, because the investigation is not only the president's response, that is only part of the investigation.
Okay, so in other words, yourself and your team of investigators are satisfied with the level of detail that has been given here?
The level of detail given allows us to continue with the investigation.
All right. Let's then tackle when it is that you intend concluding these investigations, because that's where the nub of the complaint is from various quarters, in particular the political parties that came to your office. This matter, as you've just said, it became public in early June. I don't know when it is that you started investigating as the office. However, are you any closer to completing this investigation and, importantly, making public the findings?
As I've said, the investigation is quite advanced. We are intending on completing the investigation timelessly, but we need to make sure that we produce a quality report, not only for the integrity of the investigation, but for the integrity of the institution.
Advanced means by when is the public likely to know when it is that this report will be released?
As soon as the investigation is complete. We are working around the clock to ensure that we timelessly issue a report in this matter, having followed due process in the investigations.
You're not giving away much, acting public protector.
It is, but there's quite a lot of process. I mean, you gather evidence, you analyze, you make follow-up leads. We are at that stage where we are probably on the 8th arch lever file of information that is before us. And there's still more leads to be followed, because each and every response gives us more leads to follow, which we have to follow because we have to close every gap in the matter. And thereafter, it is issues of doing research of the law applicable, drafting a section, what we call a section 7-9, if there's any information indicating possible adverse findings. If not, drafting the discretionary notice advising that there's no information before us, awaiting those responses from the parties, and thereafter doing further research, processing the new information that you would have derived from those reports, and then drafting a final report. So it is quite a process. However, we are working tirelessly around this matter. We've beefed up our investigation team to ensure that the report is finalized timelessly, because we understand the urgency that South Africans had and the public at large that this matter be finalized. However, we have to do it within process.
I'm going to have to push you a little bit here. This investigation, it would have started in June. If you count, we are now on month number 5, and if the reporting I've seen is anything to go by in terms of what your timeline says as a benchmark to investigations at the Public Protector's Office, 6 months roughly is that time. Are you able to tell us here and now that next month you could be tabling that report publicly, or perhaps the month after that?
I'm not certain where you get the 6 months from, but I would just like to illustrate to you through similar matters that we've done in the past, EMEA matters. I mean, the Nkandla matter took almost 2.5 years. The CR17 Bosasa matter took between 8 to 9 months. And as you know, that matter was reviewed by the court, and some of the findings made by the court was the inadequacy of the investigation that took place in the matter. But our EMEA matters have never gone anything less than about 8 months. The state of capture matter took about 7 months. It still went to an inquiry, which was a continuation of our investigation, which took a further 4 years, which we've all witnessed as the public.
Based on what you have, the information you have, do you think that law enforcement agencies in this country could possibly have a solid case against the president?
We've got information before us, but we don't have what the law enforcement agency have, so we are not certain. My understanding is that they too are still in the process of investigation. So at this stage, no comment in that respect can be made.
The reason around the timing, Advocate Gcaleka, it has to do with, firstly, the commitment that was given by Advocate Mkhwebane that within 30 days a report would be out here. And I'm sure you know where I'm going with this. It's got to do with the accusations that you are delaying this report in part because you are trying to shield the president here from accounting. Is that in effect what you're doing?
I'm not certain about the report you are speaking of that Advocate Mkhwebane said she would release within 30 days. When I came in as acting public protector, the allegations letters which were written had indicated that this is a preliminary investigation. Now, what a preliminary investigation is that you collect information to assess whether you should go into a full-scale investigation. And at that point, even your investigation plan would be based on a preliminary investigation, but not a final investigation where you issue a report either with adverse findings or whether the allegations are unsubstantiated. Now, having looked at the matter, and having looked at EMEA as an act, EMEA says the public protector must investigate. It doesn't give us an option to assess first whether there is room whether to investigate or not. And therefore, we have embarked on a full-scale investigation. A new investigation plan has been done on the basis that we are investigating in line with EMEA.
So what you're saying is that the earlier assertions that this would be an interim investigation or an investigation that is meant to be done quickly in order to give some outcome. You're saying that you've had to reverse all of that in order to do a full-scale investigation because this has to do with the members of the Executive Ethics Act.
Firstly, the preliminary investigation would not give an outcome whether the matter is substantiated or not. It would give an outcome whether you want to investigate or not, for whichever other reason. But in this case, it is not applicable because we are dealing with the Executive Members Ethics Act. And the Executive Members Ethics Act says the public protector must investigate. It doesn't give an option. Therefore, we are currently embarking on a full-scale investigation in line with EMEA.
Now we're getting somewhere, Advocate Gcaleka, because if you're saying that a preliminary investigation does not apply here, is that what was promised, which then talks to the 30-day deadline?
I don't know really, Chloe. I've never come across that information. Like I say, I'm not certain what you are speaking of, that a 30-day deadline was made. My interaction with the investigator who has been in the matter and is still currently in the matter has never been about a 30-day deadline. But indeed, the allegations letter that they had issued was speaking to a preliminary investigation, which was not correct because that is not what the Act requires of us.
At no stage did you have a conversation with Advocate Mkhwebane about whether or not she had promised a 30-day deadline relating to Phala Phala?
No, because it never came into any speaking. It's the first time that I'm hearing of it.
Is Advocate Mkhwebane telling the truth when she says that when she was suspended in June, matters at that office started being delayed? Reports, investigative reports, have seen delays. Not just this Phala Phala one, but other matters. Is there any substance to that?
As you are aware, Kholeka, we did file an affidavit, which was signed by myself from the Office of the Public Protector, where we laid out the running of the office, including investigative matters, which are on par with timelines which we have set. Of course, we do have a backlog which even runs into her term, which we're still dealing with. We have finalized 29 investigative reports, which we've released at the end of September, and the target was to finalize 27. So we are on par with the work that we are doing. And over and above that, by the way, we have gone into assessing matters we've had in the office previously to see that whether we are in line with process and law in the matters that we are working on.
It's interesting that you bring up this matter of 29 investigative reports that have now been finalized and indeed released, because in your court papers relating to these delays around Phala Phala, you make mention of 14 reports that you would have released at the time that Advocate Mkhwebane took a sabbatical in 2021. This was for about nearly 3 months. And you say specifically that those reports have never been subject to or set aside in a judicial review. Why was that important for you to mention?
What is important, Kholeka, is that we need to outline process. I am process-driven. And the team at Public Protector South Africa that I worked much closely with at the time, and even now, is acceptable to the approach of being process-driven, so that we can ensure that we issue reports which have quality, reports through which we would have followed process. For instance, at that stage, even before the Constitutional Court judgment came out that we need to give respondents an opportunity to respond even into the remedial actions that we are going to issue. We actually started with that process during my term, my short stint at acting during that period.
Yeah. You are a process-driven leader. Are you suggesting that the other leader has not particularly been committed to process?
I'm not comparing. As I have spoken, I've never referred to Advocate Mkhwebane nor to her work.
Yeah. Interesting also in your court papers that in your response to these undue delays, you say the following, and I want to quote you directly again. The Office of the Public Protector has a duty to protect the credibility of the institution and its constitutionally mandated independence and impartiality. Those are carefully chosen words in a response to alleged undue delays. Why the choice of these words?
Because that is our constitutional mandate. That is the foundation upon which the institution has been formed about. So in everything that we do as an institution, particularly our core business, which is investigation, we must be guided by those constitutional values.
Something does stand out, though, about you choosing those words. First, you have just said here now that you are a process-driven person, and then I've also just given you your wording in your court papers that the credibility of the institution, importantly also the independence and impartiality of that institution, is paramount. Again, I ask you the question, why is it that these, for you, stand above everything else?
Because the institution is formed on the basis of the Constitution, and it is driven by the law. And that is what the Constitution and the law calls upon us to do and stick to, and nothing else.
I guess the reason I'm pressing on this, it has to do with the parliamentary inquiry into the fitness of Advocate Mkhwebane to hold the very office or the very position in which you are acting now. And in that inquiry, we have heard from Ms. Ntoriseng Motiti, who is an executive manager in that office. She spoke about, quote unquote, a hostile environment. We've also heard from another executive manager, and that is Ms. Nelisiwe Tejane, complaining about the pressure that people are rushed into, or people are rushed into investigative procedures. Has that been the experience since you arrived at that office working alongside Advocate Mkhwebane?
Totally, yes. Yes, there has been a push to ensure that the target is reached and that work is done. So that I cannot deny.
In the process, would you say it has compromised the work of that institution?
Well, there are instances, and I don't want to give a blanket approach into this, but there are instances where reports would go out and we are not fairly comfortable with those reports.
Is that the reason why, therefore, in your 14 reports that were released, during which time Advocate Mkhwebane was on a sabbatical, you point out that those reports were neither the subject of or reviewed by a court of law? I'm taking you back to your own words where you say you are a process-driven person, and more important for you, the institution and its credibility is at stake here. Is that the premise upon which you are leading that institution now?
I do not want to link the two. I don't want to get involved in the processes of the 194. As you are aware, I led the institution for almost 3 months in 2021, and at that point, the evidentiary process at the 194 committee had not commenced. And even then, that is how I led the institution and ensured that investigations are carried out, because that is how it is supposed to be. It has to be in line with the law. And when I interpreted the law, I found that that is what it calls upon us to do.
Are you, Advocate Gcaleka, deliberately trying to undo this culture of fear? At least that's my analysis of the situation based on the parliamentary testimonies. Are you trying to undo a culture of fear that has set in at the Public Protector's office? And is that the reason why you won't succumb to pressure when people say, give us an interim report around the Phala Phala farm matter?
What I am doing, Xoli, is to lead that institution on the best way I know how to lead, in line with the Constitution, in line with the law, which calls upon investigators and the institution to do its work without fear, favor, or prejudice, and to ensure that we are independent and impartial, but most importantly, for the credibility of the institution, the investigators who do the work, and the impact of our reports. Because should we rush matters through, it does have a direct bearing on the impact of the report when the report is ultimately set aside because not due process was followed.
If the Palapala farm investigation is ultimately, or that investigative report, is ultimately released under your watch, under your stewardship, is your determination here to see to it that that report, even if it is taken to court for judicial review, that the manner in which your investigators have dealt with and satisfied themselves that this is a thorough process that we've gone through, are you trying to shield any reports that are released under your watch from being reviewed in court?
From being successfully reviewed, yes.
Successfully reviewed,
yes.
Indeed.
So, most definitely, not just in Palapala, in all the matters, even the 29 matters which we've released last month, we made certain that at least we are in line with the law and the facts. And look, it might be successfully released, but the comments that the court made should not be comments such as not due process was given. Yes, we can err, like any other. Hence, we also have separate appeal or review process even amongst the courts themselves, because we are human beings and we are susceptible to erring, but it shouldn't be a deliberate act.
Did you find it strange that at one point a CFO, a Chief Financial Officer, was seconded to the Public Protector's office, but this is an individual who had come from the State Security Agency? Did you find that strange?
I wasn't at the Public Protector at the time, so I do not know the circumstances under which that decision was taken, and therefore would not be able to make a meaningful contribution to that.
But you ultimately would have become aware of such a situation. Is that something that you would allow under your watch now?
It depends on the circumstances. It depends on the circumstances that we find ourselves as the office, the reason for that, the skills of that particular person, and what contribution they would make to the office, no matter which institution they come from.
I'm wrapping up. And I want to ask you a direct question. And it has to do with the credibility of that office. Is it your view that under the stewardship of Advocate Mkhwebane, that office has suffered in terms of its credibility? Would that be your
view? There's been different comments from the courts, which I note and respect, from the Section 194 Committee, which I note and respect, and hence the Section 19 Committee is now seized with that particular matter. I really haven't made an assessment to say, when did this issue begin, how far, what has been her contribution, and so forth. Therefore, I'm not in a position to say the office or the institution has suffered a blow in its integrity during her tenure.
There is one other report I want to explore with you, but we'll do that in a bit. But I do want, before I go to a break, to ask this final question, and it's around Advocate Mkhwebane. It would appear, since her suspension, that there has been a bit of a back and forth between yourself and her through court documents. If she were to return to office, would you be comfortable working with her, working alongside her, or would you rather look for another job?
Not at all. I would definitely still continue with the work that I'm doing. As lawyers particularly, and I mean, I guess even in your profession, the fact that you do not see things the same way doesn't mean that it is personal. It is merely work. And work has to continue no matter who is at the helm. I still have my position as the Deputy Public Protector, which I've also been appointed through the same parliamentary process through which she has been appointed, which requires of me to be independent and impartial and to do my work in line with the Constitution and the law, and nothing will take that away from me. I will continue to do my work in that line.
Right, let's take a pause there, and when we return, we wrap up the discussion with Advocate Kholeka Gcaleka. You're watching Newsfeed AM. If you're just joining us, you find us right towards the tail end of a discussion with the Acting Public Protector, Advocate Kholeka Gcaleka, in studio with me. And let me put this question to you, and it's around one of the reports that you released on Friday, and it has to do with the former Defense Minister, Nosiviwe Mkhwebane, whom you have found against her adverse findings. But interestingly, you did not find any guilt on the part of the President, and it has to do with that trip to Zimbabwe, where she would have ferried ANC members, and yet she would have gone there in her capacity as Minister of Defense. Just explain that to us.
Well, in reality, the Public Protector's investigation in this matter was overtaken by events. Because immediately after the matter came out in the public, the President did take action and he admonished the Minister. So ours was, however, to continue to find out what could have been the systemic issue and whether indeed was there a breach, which we did confirm. Therefore, we could not make another remedy against her because it would have resulted in double jeopardy. General law applicable is clear that you cannot punish somebody twice for one act or offense. So that is what the case is in this regard. However, we did make remedial action that the President must ensure that there's adherence to the applicable legislation in this regard.
So what would be the penalty? Very, very briefly, she's no longer Defense Minister. She's now a Speaker of Parliament. So what possible action could be taken against her now?
There's none. Hence, we didn't make any remedial action against her because already the President had admonished her, ensured that she doesn't receive a salary for 3 months, and also on the side of the department that they recover the money from the ANC. But remember, our investigations are not always about the human being. You need to look into the root cause. What is it that was not adhered to? And in this instance was the Defence Act and the Ministerial Handbook. But it is also to ensure that officials, also because they are entrusted with the functioning of the PFMA, that they ensure that the executive authority, even on their side, adhere to the applicable legal prescripts, but also that the President ensures that his cabinet adheres to the applicable legal prescripts.
Advocate Kholeka Gcaleka, let me thank you very much for your time, Acting Public Protector, and thanks indeed for clarifying some of the issues here.